Good morning. I'm Jim Benish, and this is part 3 of a series of discourses about injustice going on in Hawaii. Unfortunately for me, I find myself muddling my way around and through significant stacks of paperwork that the detective inside of me has written, collected, assembled, and placed in piles, all neatly placed in chronological order and in distance from my reach according to their importance. It's all as if I was still working as a police detective. Why? Because it's the way it's done. I'm not going to present the actual documents referred to in this video. If you're interested, you can view them, including the emails, at code4blog.com. The title is Fear and Mayhem in Hawaii, Part 3. The murder cases of 2 little girls, one in Colorado and one in Hawaii, have seduced me and become entangled within my life. I have written one book about the first murder, Tracy Neath, in Colorado, and begun another about the second case, the murder of 4-year-old Lacey Woolsey Ruff in Hawaii. But no matter how much I write, in the expectation that the last word of the last page would end it all for me, it just becomes more intense. There's more information, and victims reach out in a desperate attempt to accept their own quests. But it's not just about determination and feelings. Human beings suffer when they have lost someone they love or lost their worldly possessions to the corrupt. They have, as I have, the feeling of loss of something more important. It's more important than our dignity or the respect of others, or even our loved ones. We feel the loss of our country, our freedom, and our human rights. Without these things, we are nothing but third-world multicultural slaves. The first 2 parts of this were put together in an impersonal and unprofessional, I might add, attempt at journalistic documentation. Well, I'm not a public speaker, nor do I want to become one, but I owe you all, the people who actually looked at the first 2 videos, an apology. I don't know what I was thinking. I used another journalist's television documentaries on the first video, and on the second, in an effort to escape public scrutiny or embarrassment, or just plain sacrificing my privacy, I actually reduced myself to using Microsoft Talk to produce a talking video. God help me. I loathe transforming this from written words to a video of myself that can be watched by anyone with a computer or cell phone and an internet connection. But this is exactly why I woke up at 2 a.m. this morning. The stakes are too high. They're high enough that I must not hide. I'm an old man, I'm retired, and I personally do not enjoy much more than rebuilding the carburetor on my truck or going fishing or writing a novel. In reality, and to those of you who sit back and do nothing but criticize, well, you are the real problem. It's you. Yes, you, who have caused me to do this nasty, nasty thing. I will now become a male version of a Piers Morgan who tells the truth. I'm going to be a little redundant and give you a short recap of how this all began for me. This story began simple, at least simple to me. I thought I would assemble a homicide case information, give it to the police, wipe the ink off my fingers, and return to life. This is how it was done back in the 90s, and I thought this is how it's done today. No. I became incidentally involved in the murder of 4-year-old Lacey Woolsey Ruff in 1993 when I was working on the murder of 7-year-old Tracy Neath in Colorado. The connection was 2 brothers, Aaron and Todd Shawnlaw, who lived down the street from where Tracy Neath lived. And as it turned out, Aaron Shawnlaw had been arrested in Hawaii for the actual murder of Lacey Ruff. Of course I was interested in these 2 young men. It only took me a couple of days to snag up Todd Shanlaw, who had returned from Kauai to Colorado without his brother, Aaron. Aaron had been arrested for the murder in Kauai. But I couldn't make a culpable connection between the brothers and the neat murder. After I interviewed Todd Shanlaw, I had just had the feeling that something wasn't right. Here was a guy who began by telling me how much he loved his brother, Aaron, and how bad he felt about the murder, and then throws his brother under the bus, while at the same time promoting his own moral fortitude. But the Kauai case was not my case and not my concern. Just the same, I picked up the phone and called the Kauai Police Department and told them what Todd had related to me about the Ruff murder. They were not interested. I should have learned my lesson from that conversation. Back then, I had no reason to believe that I would even remotely become tangled in this Kauai mess. Years went by. I was minding my own business. I relocated to San Diego and was living peacefully on a beautiful sailboat when in 2011 or 2012 I was contacted by two women who lived in Oregon. They had read my first book I wrote about the Colorado Neat murder. They read about the Shanlaw brothers, and one of them had some sort of personal interest in Todd Shanlaw, who was living with her. This is when the Kauai abyss began to rise its ugly head. Tiffany Kaneko from Oregon claimed that Todd had told her that he was present when Lacey was murdered in Hawaii, and in fact it was he that placed her body in the ocean. They had both been drinking that night when Todd made this confession, and when Tiffany Kaneko heard what Todd said, she became enraged and physically assaulted him. The police were called, and they took intoxicated Tiffany to jail. The cop who transported her was writing down Tiffany's rants about what Todd had told her while he was driving her to the prick jail. Now it's all in the police files and in my files. I interviewed both women by phone. Then I began to read my old 93 notes. I had more questions. I called people in Colorado who knew of the Shanlaw brothers, and it didn't take me very long to realize that maybe Kauai had either arrested the wrong man for the Ruff murder, or didn't arrest Todd, who probably had something to do with the murder also. Again, I made a call to the Kauai Police Department. It was now 2012, and I talked to the same guy I had spoken with in 1993. And again, they were not interested. When I asked if I could review their file, this police officer told me that if I wanted to know about the murder, to call the local newspaper. That attitude was difficult for me to stomach. I had a little internet blog going and wrote an article about this situation. And when I began to get communication from people who lived in Hawaii, it seems the Kauai PD's attitude about police work was not new to them. They were all complaining about corruption, but this had nothing to do with the Ruff murder to me. But the complaints and information just kept rolling in on this blog site I had. Eventually, I had obtained the police files on the Ruff case. It wasn't easy to get any information from the police department. The files were heavily redacted, pages were missing, and to pour salt on my wound, the KPD records clerk told me that she had given me everything that I asked for. I finally had to telephone Nick Corson, the Kauai attorney, and made a complaint. He was able to get me the Ruff autopsy and the evidence logs. I don't think he realized how valuable these documents would turn out to be, and neither did I. The autopsy report indicated that little Lacey Ruff died from saltwater drowning. This substantiated what Todd Schaumlaw had told to Tiffany and disagreed with Aaron Schaumlaw's confession. I had interviewed more people in Colorado about the Schaumlaw brothers and had even gotten possession of the Ruff court files. The real eye-opener for me was when I began to speak with witnesses who were there during the Ruff murder investigation and speaking with Lacey Ruff's relatives. These people told me that they had never been interviewed by the police. One woman who was an eyewitness hung up the phone on me. I'll never forget. Her name is Mary Glass. I'll never forget her words before I heard the terminal click. She said to me, "What I have to say is irrelevant." Irrelevant? She's an eyewitness, and she thinks her information is irrelevant. I wonder why she would say such a thing. This woman actually saw the suspect carrying Lacey Ruff's body into the ocean, according to police reports. There's a lot more to say about the Schaumlaw brothers and the murders of Tracy Meek and Lacey Ruff, but let's fast forward to 2015. I had compiled all of the documents and interviews I could and posted another blog about what I had discovered. The resistance I had encountered from the Kauai government, and in particular the police department, was notable. I interviewed and became friends with Lacey's father, Timmy Woolsey. I interviewed the diver who accompanied Timmy into the ocean and found the body. I contacted other relatives. One day, I received a telephone call from a man who said his name was John Burgess. Burgess told me he was a cold case investigator for the Kauai prosecutor's office, and after viewing my blog, and he had also apparently heard a telephone interview I did in Hawaii, he had been assigned to look into the Ruff case. I had a good chat with him and sent him all the information I had, including telephone conversations. I later learned that his partner or assistant in this investigation was the same KPD cop that I had spoken to before on the phone, who told me that the police were not interested in looking into the case. Odd. Soon after I received a telephone call from Timmy Woolsey. He told me that he had been contacted by Burgess, and that Burgess had made him feel threatened should he continue to speak with me. He said Burgess had belittled me and said things like, he doesn't know what he's talking about, and so forth. After reading the Kauai District Court documents, it became clear to me why the Kauai PD didn't want this case opened. The prosecutor, Justin Kohler, had been interviewed by the Hawaii Channel News and was asked why he would not reopen the Ruff case. His answer was this: Tiffany Kaneko had recanted her allegations against Todd, and Todd, the suspect, didn't want to speak with the police. Case closed. After reading the district court files, I was astounded. The KPD had filed a case against Aaron Schaumlaw that didn't include statements from witnesses and certain evidence that pointed to Todd Schaumlaw, not Aaron. It's court procedure that you also include other culpable evidence in the crime, not just evidence against the suspect. These items These documents were in the police reports given to me by the KPD Records Department, but were not in the court's case files, nor in the detective's affidavit for probable cause for arrest of Aaron. The KPD had apparently intentionally kept this information from the court, knowing that by including that information, they did not have a case against Aaron. And even under these circumstances, I was still surprised that the court took the case against Aaron because there was no actual physical evidence that he committed the crime. The only evidence was Aaron's brother Todd's statements that Aaron had admitted the crime to him and Aaron's own confession. I interviewed Aaron in 2012 while he was in prison in Arizona. And Aaron said many things that were incriminating, but didn't know certain things about the crime that only his brother Todd knew. Aaron was a diagnosed schizophrenic and took medication to keep him in this world and out of another. He had been out of his medication on the day Ruff was murdered and said that he confessed to the crime to save himself a sentence of life in prison without parole. Doesn't matter. The judge is not supposed to allow these kinds of things to happen. And last but not least, it was Todd who in 1993 told the police where the Ruff body was placed in the ocean. And it was Todd who was wearing the same clothing that Mary Glass saw on the person carrying the body into the ocean, not Aaron. The police report cleverly only refers to the people in the affidavit that they filed as Sean Law. The court would naturally assume it was Aaron Sean Law, not Todd. For me now, this murder case has taken a new form, a new body, a new issue that is bigger than any of the murders of the little girls and the corruption in Hawaii. Based on the information that I have just spoken to you about, the information that I have personal intimate knowledge of, and based on the 5 or 6 other Hawaii citizens who claim corruption and collusion within the Hawaii government, I must come to the conclusion that there is in fact enough evidence to warrant a full-blown investigation by the federal government. But who in this government? There's an indication of involvement by numerous Hawaii police and prosecutors' offices, and even in the courts. I have written to the FBI and the U.S. Attorney's Office and have not even received the courtesy of a notification of receipt of my documents. In my mind, the only answer is a federal grand jury. Certainly, the federal courts cannot be corrupt. But I'm just a citizen. Can I ask the courts for a grand jury? I was skeptical. I had already sent letters to the U.S. Attorney and the FBI and received no acknowledgement. I did some research, and here's what I learned. First of all, it didn't seem that I should go back to the FBI and the U.S. Attorney and ask them again for an investigation. Because a lot of the indications you get on the internet suggest that that is the first step to take. Well, I took it. Didn't work. The Supreme Court rules say, in support of the U.S. Constitution, that a judge must convene a grand jury when in the best interest of the public. It doesn't say the request must come from a government agency. And despite the fact that I have been ridiculed by attorneys for even thinking that I could do such a thing, there are many court decisions that support the notion that a citizen can ask a federal judge to convene a jury or the notion that a citizen can communicate directly with a grand jury under certain circumstances. For instance, as recently as 2004 in the case Hott versus Yarborough, before appellate judges Skillman, Coburn, and Wells, Larry S. Lloydman, who was the appellant and represented himself against a deputy attorney general who was in cahoots with 21 individual county prosecutors, argued on the question, can a letter from a private citizen alleging violations of criminal law be processed and delivered to the grand jury? It doesn't say just delivered to the grand jury, it says processed. That means doing some paperwork to me. And the prosecutors are questioning whether it can even be processed. The opinion of the court was delivered. The court held that a letter from a private citizen to the grand jury alleging the commission of crimes and seeking investigation was absolutely privileged and could not provide the basis for a libel suit. Specifically, the court said, and I quote, "The questions presented by this appeal are whether a citizen of New Jersey is entitled to directly communicate to a county grand jury a request to testify about a matter within its jurisdiction, and whether the grand jury has the right to receive communications. Our answer to both is yes." My question is this: if these prosecuting attorneys are elected to represent the people, why are they objecting? So, in December 2015, I submitted an affidavit request for a grand jury investigation to Federal Judge Michael Seabright, District of Hawaii, to be given directly to the grand jury. I assumed that the grand jury had been assigned to investigate the allegations and that the appropriate agencies would be assigned to assist the grand jury. These assisting agencies would be the same U.S. District Attorney of Hawaii and the FBI office in Hawaii, and possibly even the Internal Revenue Service. But they would only be assisting the grand jury, and therefore would be in a position of accountability. I assumed that my job had been completed and no further communication with Seabright's court was necessary. I was wrong. My allegations were many, but primarily murder and violations of the Federal RICO Act. There were over 60 listed defendants, and on December 29th, about a week later, I received a letter from the court. This is the letter, and I'll read it to you. Mr. James Benish, R.E., your documents received on December 16, 2015. Motion to convene a grand jury. Now, this is just a letter, but to me, this is also a receipt. Dear Mr. Benish, the clerk's office is unable to process your motion to convene a federal grand jury. Please refer to the United States Attorney's Office for assistance. We will hold your copies of said documents for 30 days. Thereafter, if we do not receive instructions from you, your documents will be destroyed. If you have any questions, call our office. Destroyed? I don't think so. That is a federal crime punishable by 3 years in prison. called the courts. The tapes, the recordings are also on my blog. But basically, what the clerks told me was that they took it upon themselves to make this decision. The reason they told me that is because my question to them was, and knowing what the law says, by what authority do you have to decide what goes to the grand jury and what doesn't? And by what authority do you have to destroy court documents? The answer I got was, it's a general opinion. I said, a general opinion of who? Just a general opinion, she said. Okay. So I wrote a letter, an email, direct to Judge Seabright. It's a long email, 2 pages, and I'm not going to read the whole thing to you. But basically what it said was, I asked the good judge who was calling the shots in his court, he or his clerks. And if it's he, who I assume holds responsibility for these clerks, I reminded him of a few U.S. Supreme Court rules of criminal justice that needed to be followed, and listed them for him to review. The next week, I got a message, a voice message on my cell phone. Hey, Mr. Benish, we gave your affidavit to the grand jury. Gave it to them. I didn't hear the word process. Although there is articulation in the details of these Hawaii corruption allegations, an additional question is that everyone, including myself, should ask is, what protects us citizens from the confiscation of life, liberty, or property in the United States? And what guarantees a U.S. citizen the right to protect his property from corrupt lawyers and judges? The answer is twofold. The Fifth Amendment and the 14th Amendment to the Constitution, but in particular the 14th Amendment, referred to as the Due Process Amendment. That says, and I quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." I assume that includes me and my affidavit. But who enforces this amendment? The Justice Department is supposed to. What happens when the Justice Department will not perform? The participation of a U.S. federal grand jury or a citizen's petition to the appropriate agency is the next step. Judges are required by law to bring forth a grand jury when asked to. There are many court opinions that have to do with the 14th Amendment and or grand juries, but these opinions do not change the amendments, nor do they change the meaning of the amendments. On June 16, 2016, there had been no indication that an investigation had actually taken place in response to my grand jury affidavit. The victims in the case had constant communication with me during this time, and none of them had been approached or interviewed by either the FBI or members of the U.S. Attorney's Office. I admit I was beginning to have doubts as to the credibility of Judge Seabright's court. Or was it possible that the FBI or the Hawaii U.S. Attorney was trying to quash the investigation? On 6/21 of 2016, I sent an email again to Leon Abernathy, George Seabright's clerk. I wanted some verification that the paperwork, my affidavit, had been properly processed, as described in the court decisions. I knew that any documents that came into the possession of the court must be logged in and properly processed. I knew that these records not only must be logged in, they must be entered into the electronic PACER case management system. This is an accessible filing system of all court records, and this system was mandated and signed off by Judge Seabright himself, because the Supreme Court places the responsibility of proper court procedure on the individual district judges. However, the Supreme Court still have produced their guidelines, and the individual district court judges are not supposed to vary from the guidelines. I have a PACER account, and I could not locate any documents referred to my affidavit or my name, or the victim's name. They weren't in the system. I thought that maybe such a record of documents might not apply to grand juries, because grand jury proceedings are secret. But the processing process to the grand jury, and then maybe from the judge or the grand jury to the investigating agency requesting assistance, wouldn't be included, in my view, as a grand jury proceeding. That is administration. There also is no such exclusion in the Hawaii Rules of Procedure that Seabright has signed off on. Several emails were sent back and forth between me and Leon Abernathy. Based on the emails from Leon, sadly, I became aware that there were no court documents generated as a result of my affidavit, and no court instructions from the court to the grand jury as required by the rules of practice for the United States District Court for the District of Hawaii or the U.S. Supreme Court instructions. It was my belief that there could only be one reason why Seabright's court did not log in my affidavit and did not generate proper transmittal documents to the grand jury or the FBI or the U.S. Attorney's Office. However, Abernathy claims in one of her emails that she picked up the phone and called and told the U.S. Attorney's Office about the affidavit, and says she can't remember who she talked to. So it appears to me that the only actual proof that this investigation request in my affidavit exists is the one that I have, and the letter, the first letter they sent to me telling me they're going to destroy the documents. In April 2017, I was contacted by a new victim, Miss Bobby Duran. Mrs. Duran had been referred to me by one of the original victims listed on the affidavit. This is the incident that led up to my discovery that nothing had been done in the court system. Mrs. Duran is an elderly and handicapped person, and she told me that she was on the verge of losing her multiple properties to a local Hawaii attorney named Paul Sulla. Remember that name, Paul Sulla. She told me that her husband was deceased and since his death, Sulla had been relentless at filing fraudulent claims in Kauai courts in an effort to assume ownership of the properties himself. He wasn't representing the client, he's representing himself. Possibly sometimes he gets one of his buddies to go into court with him, because I don't think the courts would appreciate an attorney showing up on a foreclosure case of some kind representing himself. However, in these courts, nothing surprises me. I was very familiar with Mr. Sulla, as Sulla had been listed as one of the major defendants to multiple allegations of violations of the Federal RICO Act. Mr. Rand's story was all too familiar to me. Mr. Sulla had been accused of numerous fraudulent seizures of private property, using his abilities as an attorney and recruiting assistance from fellow attorneys and judges, and even title companies to assist in his efforts. Ms. Duran told me that she could not get an attorney in Kauai to help her keep her property. She told me the attorneys she had contacted wouldn't go to court against Paul Sulla and his judges. She said that Sulla had even filed a forged tax return signed by her deceased husband after his death and presented it in court. After listening to Mrs. Duran, I told her I would contact Seabright's court and find out how to add her to the list of victims. A series of emails transpired again between me and Leon Abernathy, who only initially referred me to the U.S. Attorney. But my persistence prevailed, and she finally broke down in one of her emails and admitted, "I didn't do any paperwork. There's no documentation about your affidavit," she says. Next, an interesting thing happened. The same day I was communicating with Abernathy, I received a phone message from FBI agent Jessica Schwab. The same day. It was on April 7th, 2017. So I entered into an email conversation with Agent Schwab of the FBI. Agent Schwab had claimed she was calling me because of a letter I had sent to the Washington, D.C. FBI office earlier requesting to add a victim to the case since I couldn't get anybody in Hawaii to talk to me. This request was made on the FBI webpage. Agent Schwab asked me about the case. She said she couldn't find a record of the case. So I sent her all the information. My affidavit, including my suspicion that nothing had been done with it. I said I wasn't even sure the grand jury had been provided the affidavit. Several emails later, Schwab told me there had been information provided to the FBI. She wasn't sure what section or who the agent was that was handling it, but she was going to check into it. And she would get back to me. I haven't heard back from her up to this point. Today's the June 3rd. So, in summary of this part 3, we have a series of phone conversations and emails transpiring between me and the FBI and Judge Seabright's court clerks, two court clerks actually. And these emails indicate to me that proper procedure was not followed in handling this request for a federal grand jury. So we're on the federal level now. We're not in district, county courts or any of that stuff. We're on the federal level. And so we're not dealing with state attorney generals or county prosecutors. We're dealing with the feds here. It's my suspicion that the feds and the U.S. attorney in Hawaii didn't know anything about this. I can't prove that they did. This is why I kept asking for the transmittal information. This is why I did search in the PACER system. That's the system that Agent Schwab goes to find the case number. She goes to that system. It's a nationalized, commonly used document filing court system. Not all courts use it, but Seabright's court does. So we have these emails and we have these phone conversations, and we're not talking allegations of shoplifting. We're talking violations of the RICO Act, organized crime. We're talking about murder. We're talking about destruction of documents. We're talking about concealing documents. Many, many different allegations that fall under the federal jurisdiction, and the document was not processed. So I'm going to leave you at this. There's going to be a part 4 and maybe a part 5 because I'm not finished with this. But putting this on video benefits me personally because it's a record of what's going on here. And as long as this record exists on the internet, it can't be touched or eliminated in any way by anyone. People save it. It'll flounder around on the internet way past my lifetime. I keep meticulous records, and from now on you will hear about them. So subscribe to my blog, because that's where this video is going. It'll be a YouTube video, but it'll be on my blog, and on my blog you will see all of these documents. You'll be able to read the letter from the courts. You'll be able to read the printed emails back and forth. You'll see pictures of the defendants. And by the way, part 4 is going to be about the individual victims, their cases, and the defendants. There's not going to be a whole lot in there about the Ruff murder because that's pretty much covered in part 1. But the individual, the RICO allegations, we're talking bank involvements in Hawaii, we're talking foundation, the Hawaii Community Foundation. They're a big one. They're a big one. They're in there. The members of the Hawaii Community Foundation are the who's who of Hawaii. That's where I'm going with this. So I'm going to say goodbye for now, and protect yourself and do some study yourself. Pass this on to as many people as you can. We need to start using the tools that are available to us to take back our country, take back our republic, and take back our Constitution. Don't sit back and wait for someone else to do it. It might be too late. If the federal government is involved in this little state of Hawaii stuff, there's no telling what's going to happen. Thank you.